Members, we formed a quorum. May I call the meeting to order? Please invite the administration to join us. Can we first confirm the minutes of our last meeting? Meeting dated on the 21st of April. The Secretariat has not received any proposal for amendments from members, and if members have no objection, the minutes are confirmed. Do you have Mr. Raymond Wong? It seems that you have a lot of issues to raise on that paper on safe harbour. Indeed, numerous. All right, then we will have a theme time for you. And I also have follow-up questions on previous issues. But of course, I'm not going to monopolize the meeting. It depends on whether members have other questions.
Measures.
Let us welcome the Deputy Secretary and his team. Well, we were discussing paper 442-01. Basically, we have already gone through the administration's response. If members have no further questions, we will go through paper 911. Mr. Wong Yok Man has got a lot of issues for the administration, which intends to address them in one batch at the next meeting. So we'll defer to the next meeting. So can we deal with paper 911-01? Response from the administration. Thank you. Yes, we have prepared 3 papers in response to views raised by deputations. One we dealt with at the last meeting, and the other one we would like to incorporate the comments of Mr. Wong Yok Man first. And now we will go through paper 911-01 on civil liability of infringement. Well, because the property right belongs to the copyright owner, and therefore there is civil liability. So we have provisions on infringement. Some users feel that the civil liability may stifle creativity or free flow of information. That is the major concern of some users. And under clause 22, we have some interpretation of authorization, and some members are concerned as to whether this is justified. And from copyright owners' point of view, they of course like to uphold the protection for their copyright. For instance, there should be statutory compensation, and there should be new considerations for the court to consider compensation. So obviously the two parties have very different views. The most important point in the copyright ordinance under section 110, 107 and 108, there are some important factors. If the copy of the property rights of copyright owner is adversely affected, then compensation or injunction can be imposed. And may I mention Section 108 in particular. If it is proven that there's been an infringement, and if the accused has no reason to know that there is a copyright, then the copyright owner has no right to ask for compensation for his loss. But if it is confirmed that indeed there has been an infringement with the knowledge of the defendant, then Section 108(2) provides factors for the court to consider. We've added new factors for the court to consider damages, because it is quite difficult for the copyright owner to prove damages he has suffered, and we believe these factors will help the copyright owner to get his rightful compensation, and this is a very clear compensation principle. And in Section 22, we explain what is meant by authorization. Authorization can be a form of infringement, and in overseas cases, there are factors for the court to consider, and we have added that to the ordinance to allow the court to consider how compensation or how protection should be given to the copyright owner. However, copyright owners are asked whether there can be any statutory civil compensation. We beg to differ, because that means there is no need to submit evidence on damages, and if the compensation is fixed in the ordinance, that may not be fair and should not be the right direction for this ordinance, because that may have profound implications on other cases. So that's about civil liability. And we have just responded to concerns by deputations. And we have also got some general responses to comments. For instance, copyright users believe that there should be a sharing of the works of creativity. We do agree that that will allow users to have to use works of creativity legitimately. And some deputations asked about the possibility of future amendments to the ordinance to address outstanding issues. In fact, things are still developing in other places. Take the US, EU, Australia, and Ireland as an example. After they have provisions on safe harbor, they are still considering how their copyright regime can be perfected so as to encourage creativity and innovation. So this bill is just one step forward to tackle some of the issues we've noted in the cyber world. But for things like TV devices, as issues arising from TV devices, we will address these issues in future exercises. Thank you. Mr. Wong Yuk-man. Now we're more concerned about communication right and also civil liability. Now, the administration, I would say that for those who supported the administration, the response would be they have amended the ordinance in accordance with views received. But for views in objection to the amendments, the government is not really sincere in responding to their concerns. Now, I will try to be as succinct as possible. Now, let's talk about the copyright owners. They want to protect their own interests. For provisions favorable to them, of course, they support them. So they share the government's position. Yesterday, I met with copyright related associations. They want the administration to pass the bill within this legislative session. Of course, that's not possible. We'll be happy if the bill can be completed within this term. And some say that perhaps there won't be elections afterwards, and then there may be problems.
But we need to have more discussions at this Bills Committee. And as legislators, we should look at the submissions. We have over 8,000 of them. I know you have spent a lot of time on addressing them. However, we really have to look at all those opinions. So for copyright owners, of course, they have to protect themselves. So that's why they agree to those provisions that are beneficial to them. And some of them even ask the government to enhance the bill so that there can be more stringent rules. For our position, we do not want to be lopsided towards a certain side. Now, the major spirit of the bill is that the freedom of speech and authorship should be protected, and we have to strike a balance between the two. And the response, let's look at B. Page 13 to 16 of the paper. Copyright owners' opinion. Which paper are you talking about, Mr. Wong? I'm talking about communication right. What's the paper number? I haven't finished last time. I'm just going to follow up a bit about last meeting. Last time we just had a little discussion about this. I think we almost completed the discussion. Now you have the whole floor to you. No, it's not like that. I have asked if other members want to speak. Now we are having a meeting here. Other people haven't indicated that they want to speak. If you don't give me a chance to speak about this, it doesn't matter because I still have numerous other opinions. I hope other members would also speak. The paper we are looking at is 911. Chairman, I'm not repeating myself. Last time I haven't said this. I want to follow up on what I talked about last time. We were talking about exclusive news last time, and now I'm not going to follow up on that because you haven't given me a reply. I want to talk about criminal liability and communication rights now. Chairman, I'll make it simpler. I'll just ask 2 questions. I have to follow up what I said last time. I haven't asked some questions. 1.1. Copyright owners support that serious infringement should be regarded as infringement. And it is said that 118(8)(b) should be amended. The authority said that under the circumstances, this will be done. That is, the government has the same position as the copyright owners. And for 1.3, you reiterate the proposal and said that you want to afford more protection. And you can look at the original paper. You say that 28A should be amended. That is about streaming, and that includes illegal streaming, set-top box, etc. All this will be regarded as illegal. And the government's response is that when it comes to the set-top box technology, you have been liaising with the industry, you will be handling the issue, and you may also look at legislation. That means you attach a lot of importance to the proposal of the copyright owners. However, when we met with TVB, I told them clearly that we will not be helping them to lobby about this because this is not feasible. But I hope that you can give us an answer. Wouldn't you go to Avenue Street to look at those set-top boxes? You have to tell us very clearly. So, Mr. Wong, you have to tell us clearly. Now TVB has made a suggestion. So what's the government's position on this? This is the opinion of the copyright owners. Deputy Secretary. Well, thank you, Mr. Wong. Yes, we still owe you such a reply. This is very important. That includes the sale of illegal streaming set-top box and the relevant installation of such devices. I just cited TVB as an example. Let them answer you first. Yes, they made it very clear. And we also said that under this bill, there are things that we can be done. For example, for some bypassing devices, we have some clauses to address them. However, some TV stations are giving us more specific suggestions. And the paper was given to us in April, but we issued this paper in January. Yes, we owe members a response in writing. We are working on that, but we undertake that we will address these issues. And then we will continue to scrutinize the bill. Also, Mr. Kwok asked us about other issues, and we have written a paper, but members may think that's not enough. We haven't addressed all your concerns. We don't want to handle it lightly, so we are trying to give you a clear answer. Yes, there is a timing issue, but it's related, so I think we should talk about it. Chairman, I finished asking my question. I'll ask in another round. Mr. Kwok? About the overriding issue, I have raised a number of questions. I think the Deputy Secretary is considering those issues. At the same time, you have to know that we have read all the submissions by the trade associations. Unfortunately, they failed to convince me. So I hope that you should look at all the submissions and then please give us an answer from the perspective of principles. Otherwise, I will be forced to make a CSA. Of course, I do not want to do that. I want you to accept our views. Yes, we will be giving you a comprehensive answer. We do not want to rush. Yes, there have been written submissions, so we are going to provide concrete response. Please give us some time. We will definitely do that. Mr. Ma Fong Kwok, I would also like to follow up on 28A. Just now, the government said that it has promised that it will give us a reply. However, I think it was 3 months ago. So how come it took the government such a long time? I represented industry. The industry has been talking to me several times. I have urged the government to give us a reply. Now, if eventually we fail to get a reply, well, actually the government has been trying to force me to move a CSA. Of course, I cannot just promise them lightly, but the government has been dragging its feet. And I am getting impatient. I don't know how much time we still have. Do we still have time for discussion after the government gives us an answer? Well, thank you for Mr. Ma's reminder. We are trying our best to do this. But for the clause 28A in June 2011, it started to exist, and members have scrutinized it. It was supported by members. And copyright owners also supported the bill. And then there was a consultation later, and this was used as the basis. Of course, we understand that, but the technology has changed. Yes, I understand that technology advances. There are new technologies and new developments, so we have to look clearly. We do not want to rush into a reply, but we promise that we will try to give you a response as soon as possible. We do not want to make any mistake. Can you tell us about what time you will give us an answer? Because there are a lot of views. It is hoped that the government will give us an answer as soon as possible. Chairman, please speak into the microphone. We cannot hear you. It's better now. We hope that the government can give us a time frame. Can you give that answer to us at the next meeting? If you give us the reply at the last meeting, well, we will not do that. We will definitely do that as soon as possible, so that members can still have time for discussion. Mr. Chen Chi-chun, Chairman, I would also like to ask about this, because now we have a lot of meetings. I'm not saying that the government is really dragging its feet, but you have been quite slow in your response, and we still need time for discussion. Just now, you said that in June 2011 it was supported, but was it 2011, 2012? At that time, the set-top box was totally different from the set-top box now. So for the copyright owners, it's very different. I'm not on their side. I'm just telling you what the present situation is like. The technology has advanced much faster than the progress of the law. And now you are saying that you still haven't decided as to whether you will be dealing with streaming devices. So I want you to look at one more thing. Now you have 161, that is access to computer with dishonest intent. Well, don't laugh. This set-top box can be regarded as computers, and they are using this device to steal other people's programs, so they will be damaging other people's benefits. You may not invoke this piece of legislation all the time, but would Section 161 be able to deal with set-top boxes or even computer programs? If you cannot answer my question right now, you can go back and think about it. And also about the sharing of hyperlinks. Last time we also talked a bit about that. And I want the government to clarify this. If it's just the sharing of a superlink, of a hyperlink, and you cannot control the material behind the hyperlink, then that would not constitute an infringement. But many copyright owners want you to make it stricter. That is, if there is a sharing of hyperlink, have they written something else? If they say that this is Hollywood's latest movie, it's not shown in Hong Kong yet, now you can see it here, would that be regarded as an infringement? According to your principle, it should not be regarded as an infringement. Of course, I respect your decision. However, for this principle, you have to make it really clear, because just now at the next room, they are talking about human reproduction technology, and then talking about the definition of advertisement. So for the sharing of a hyperlink, would it be regarded as an advertisement? They say that when you are sharing a hyperlink, you will be writing some comments, so it should be regarded as an advertisement. So what if I don't write anything? I'm just sharing a foreign advertisement. This is just a YouTube link. Would it be regarded as an offense? We have found some Canadian presidents, and it's just for Googling. Well, Mr. Chen, we are talking about this bill. Please do not digress because we have to handle a large number of papers. We heard your view. Well, let me complete. Well, we just have one government, not two governments, right? So for hyperlinks, for the sharing of hyperlinks and the adding of your comments, will it be regarded as an offense? Well, they may not know too much about it. They may come and ask you. So I hope you can be more consistent. That's just one government.
我哋之前都講話書面，我哋清楚回應啦。
We promised to give a paper to respond to this, and members keep giving us new issues. So, but it's correct that there are different ways of drafting for different areas. Take libel or defamation or the distribution of infringing materials. Different pieces of legislation have different policy intent and rationale behind them. So we can only tell you how we deal with it in the copyright regime. We will give you a very clear reply later. And have you considered using Section 161 to deal with set-top boxes? We have got CP 491/05, 944/1415/01. When the ordinance was passed, the Secretary for Security stated our policy intent. And in the paper, we confirmed that the policy intent has not changed whatsoever. Computer crimes and copyright offences will be dealt with separately. The two will not be dealt with together, and that's the position of the Security Bureau. Of course, we can discuss with members how we have arrived at this position. Well, you said that the DOJ, no, it was the Secretary for Security. Oh, I'm sorry, the Secretary for Security. I got it mixed up frequently. So we're told that the crimes ordinance would not be used to deal with copyright offences. However, there was two charges laid in a particular case. So when one didn't work, the DOJ used another charge to prosecute the offense, the defendant. Mr. Chen Ji-chun, Mr. Wong said that he would go through this paper later. So why don't we leave it to a later stage? Ms. Claudia Mo. Thank you. We all feel that we have very frequent meetings for this BC. We don't know whether it's because the officials are under pressure, and we're asked that to give them time, and that they had to deal with new issues from us all the time. So I am a bit confused as to where we are now. Well, if you were present at all meetings, you won't have felt, we won't have this feeling. Well, I'm present at all meetings, but sometimes you were not here. Well, with you, except yourself, very few members of us would be able to sit through the whole meeting. Now, I'm quite concerned about hyperlinks. I am starting to feel confused. So for hyperlinks, sharing of links does not constitute an offense, and said that in 28A(5) of the bill, it is clearly set out. But at the last meeting, Mr. Wong said that it depended on the circumstances, and there might be the possibility of an offense. So I am still not too sure about your position. Thank you, Ms. Mo. I really want to deal with this issue when the whole paper is ready, because if I just give a brief comment, there may be issues arising from that. I think it would be helpful to members if you can wait until we give you a comprehensive paper. I appreciate your feeling that it has taken us too long, but it's just that after hearing some comments, we believe that we should think through the issues and consider overseas practice before we come up with a position. And I think we tried to explain to members. But looking at members' views and that of stakeholders, perhaps our position has not been able to address your concerns. So please allow us some time. We will certainly give you a clear account later. If members have no further comments on paper 911, can we go to the next paper? 669. 1415 bracket 02. Under Secretary, perhaps I can walk members through this paper. It is in response to issues raised by members at a meeting dated the 6th of June 2015. Members asked us to review the drafting of the proposed section 39(2)(c). In view of the difficulty in defining the extent of quotation from a work which was no more than was required by the specific purpose for which it is used. And then I was also asked to review the drafting of the proposed section 3095B to specify who determined whether a work has been released or communicated to the public. And C, the Chinese word dou, that was a point raised by Mr. Wong Yok Man. First, the proposed section 39(2)(a) fair dealing exception. Now, the section provides that for the use of a quotation from copyright work for various purposes in appropriate circumstances, under prescribed conditions, and its application is not limited to the use of a quotation for the purpose of criticism or review. It's because we have to comply with the Berne Convention for the protection of literary and artistic works. And this drafting is similar to the law in the UK. So it depends on the purpose of the quotation, and the length may be different. Why do we set a concrete limit in the law? Why do we allow flexibility? It's because the purpose of quotation may determine the length of quotation. So our drafting complies with the Berne Convention using the fair dealing principle, so long as the extent of quotation will not exceed the purpose of quotation, to ensure flexibility. And then the proposed section 39(5)(b) to determine whether work has been released or communicated to the public. The Chinese word used is dun for determine. Mr. Wong Yok Man asked whether it should be 裁定 in Chinese instead. Now, we have decided to use 裁定 because it is not necessary to go to the court to make such a determination, because there can be both judgment and subjective judgment. So we believe the Chinese term 斷定 is more appropriate than 裁定. And lastly, the term 報導 and which Chinese character should be used for the word 導 Mr. Wong Yok-man is of the view that our original word is not really appropriate. According to DFJ, both characters have been used in our Chinese legislation, and to play safe, dictionaries should serve as reference, and it is decided that we should amend the references to Bodo in the ordinance in order to accede to Mr. Wong Yok-man's view. And then whether we should use the term Dongsai, Chinese term Dongsai, for what is. In fact, the term Dongsai has both an concrete and abstract meaning. So the draftsman has considered the every factor and is of the view that the word Dongsai will be able to net all the different meanings, both abstract and concrete. Okay, any other points? No? Then the next meeting, Ms. Claudia Mo. Well, other than the term Dongsai, have you considered any alternative? Do you have any proposal? Do you have any suggestion? I cannot think of any at this moment, but it sounds awkward to have the term Dongsai in the law. I don't remember whether it was my view or Mr. Wong Yok-man's view. Mr. Wong Yok-man, Dongsai really sounds awkward. Perhaps Simat, have you considered other alternatives? Perhaps you can do so back home. Since Ms. Claudia Mo cannot give any suggestion, can the DFJ continue to consider possibilities? Well, I cannot think of any term for the time being. Speaker is off mic. Speaker is off mic. Please turn on the microphone for him. The speaker is off mic. Please, can we stay calm? And the speaker is off mic. Well, the term Dongsai has been used in other pieces of legislation. And if you look up the dictionary, you will see that one meaning of the term Dongsai can refer to any concrete or abstract thing. We see no harm in using. But sometimes Dongsai can refer to human beings, to men. As in Putonghua, well, there is this usage. Dongsai used to be Nambak. It's true, at first, Nambak was used instead of Dongsai. I think it's difficult to find a replacement or alternative. It's true that it sounds awkward because you are more used to reading English. I just don't want sentences to be lengthy and wordy and cumbersome. Well, I think we have no choice here but to accept the term Dongsai. Well, if you are used to reading the Chinese text, you'll find the English text strange. No, usually the English text is clearer. Okay, the next paper, 912. Members asked us to provide information on precedent cases involving the court's judgment on what constitutes a substantial part of the underlying work in determining whether a certain act infringes copyright in the work. If I remember correctly, it was a question asked by Ms. Claudia Mo. So this paper is written to address that concern. Now, in determining whether a certain act infringes the copyright, well, we will first consider whether a substantial part of the underlying work has been reproduced. Now, under 5 circumstances, there's for sure no infringement. For instance, only the ideas of the underlying work has been incorporated. For instance, if the underlying work uses roses and in the another work it is lily, then it is not infringement. B, only an insubstantial part of the underlying work has been incorporated. C, only works in the public domain in which copyright has expired have been used. Such works can be used freely. And D, the copyright owner has agreed or acquiesced to such usage. And E, the act concerned is one of the permitted acts under the existing copyright ordinance. There are over 60 such permitted acts, under which the use of any underlying work is not an infringement. And if there are no such circumstances, how do we make a determination? That will depends on the concept substantial part, which is found in common law jurisdictions such as the UK and Canada. Our copyright regime is mainly based on the UK Copyright Act. So in countries where they have the concept of substantiality, they do not have a clear definition of the term. They rely on case laws, and when the court determines a particular case, it would adhere strictly to these principles. Now, when a work is used, it depends on whether the substantial part has been used, and in terms of quality and quantity.
So the quality parts would weigh more than the quantity parts. The courts will be looking at the two pieces of works. Well, we'll look at their similarities instead of differences. And then the court would identify the similarities and then strike a balance. It would look at which parts they are similar to each other, or they're the same, or whether it is about the core or the most fundamental parts of the work, and which would make the original work creative and original. That is, whether the original creator's endeavor has been stolen, and that's the core part of the original work. We have cited several case laws here, some of them from the UK and some of them from Hong Kong. And due to the time constraints, I'm not going to go into them one by one. It's clearly delineated in the paper. So when assessing as to whether there's an infringement, first of all, you would have to look at the part which has been claimed to be copied, and then we'll compare it with the new work. So we will look at the similarities, whether it's a copy or it's just a coincidence. We have a case law, and as for the plaintiff and the defense works, they are very similar. And the other is Designers Guild Limited. It's a UK case law. The court considered that the copied features and the artistic expression of the plaintiff's design and its overall combination constituted a substantial part of the plaintiff's work, and concluded that there was substantial copying on the defendant's part. So they will look at the characteristics of the works. So because the parts that are similar may be different, so careful consideration would have to be given, and sometimes they would need expert views. For example, musical pieces. So according to the nature of the case, the judge would look carefully, and then it would look whether the so-called copy part constitutes a substantial part of the plaintiff's work. and whether endeavor and techniques are involved, and whether that would be the substantial parts of the plaintiff's original works. So on the whole, the judge will look at all these features. He would look at the similarities, whether those similarities are very original, very unique, or they are just general characteristics. If they are just general characteristics, for example, in the Nettersea Spa case, the court found that the subject features in the plaintiff's design were commonplace features and areas in the industry and concluded that no substantial part of the plaintiff's design had been copied. So we have cited some examples here, so this may help members understand that under different circumstances, the judge would make different decisions concerning different copyright works. Ms. Claudia Mo. Thank you, Chairman. I'm quite confused. Just now, you said that when you decide as to whether there's an infringement, you would look at the similarities. However, in one of the case law, you told us that there are differences and similarities. So you would look at both the differences and similarities, right? I don't know whether it's just a matter of wording or you are actually looking at these two parts. And also substantiality. What do you mean by that? Or it's just it is a copy, or it's just a mere coincidence? If it's just a mere coincidence, I think it would be very obvious, and you don't have to go to the court level. And if you're in Australia and he's in Zimbabwe, and it's just coincidental that you have the same design, would that be the case? So how do you interpret coincident? And also my third question is about, well, this substantial part is a subjective interpretation. You say that there will be expert witnesses. Well, if I suddenly want to design a cartoon figure for children, it's also for commercial use. If other people have Hello Kitty, but I have designed a Hello Doggy, and they are of similar appearances, and Hello Kitty obviously won't like it because Hello Doggy would look like the design, but I haven't damaged the copyright or image of Hello Kitty. So how would you look at this? I'll try to answer first about similarities and differences. I said just now that similarities would be weighed more, but when you compare similarities, you would also be looking at the differences. So when you're trying to make a judgment, you will be noticing the similarities and the differences. The government would not be ignoring the differences, but it will focusing more on similarities. And for the second question, it's about the copied parts, whether it is a coincidence or is a genuine reproduction. As for people would say that it's an independent creation. Different people may have similar ideas. For example, for songwriters, for certain bars in the choruses, they may be similar, even though one songwriter hasn't heard the song of another songwriter beforehand. But if it's a really original piece of work and it's very unique, ordinary people would not come up with same work out of the blue. So the court will look at this. So if in fact they are very common features in the industry, for example, in terms of design using circles and triangles, then it would be very easy for one work to look like another, but if it's a literary work and it's written very uniquely, and if you see another work which is very similar to that, so it would be less likely that it's just a coincidence. And also sometimes we need expert witnesses. And when you talk about being subjective or objective, we would sometimes ask the expert witnesses. They would look at the issue subjectively, but they would also use objective principles. I would like to follow up. In terms of design, Louis Vuitton, LV, that's brand, once in Hong Kong said that for a certain chair in a hair salon, well, because that hair salon is also using a more or less the same design with darker brown and lighter brown squares. I was surprised because that was not such a unique design, and they sent letter before action to that hair salon, and lately it's been judged that this design does not enjoy any patents because it's just an ordinary design and it's just coincidental. So when do I know whether it would have an exclusive right? How do I know? As for LV's scenario, I can give you some information. Well, LV took action because of the trademark. As for the square design is registered for handbags and a series of leather products. So it took action because it had registered that as its trademark. So on similar leather products, that design cannot, that trademark cannot be used. And for trademarks, sometimes copyrights are involved, and for that LV case is a trademark issue, and for trademark you have to register it. And if you go to the intellectual property department, you would find what kind of trademarks are registered. As for copyright, you do not have to register it as long as it's original. After you've created it, it would already enjoy a copyright, and the copyrights would be protected. And as to protecting the copyrights, we'll have to go back to the substantial parts. Okay, I am satisfied with your answer. Okay, let's go on to the next paper, 944. I will also be briefing members on this paper. On 6 January, 24 February, 9th April, and 4th May 2015, we had meetings, and members have asked the government to answer a number of questions, and this paper is to answer those questions. First, in relation to the proposed Section 39, explain the difference between communication of a work to the public under the proposed Section 28A and the performance, exhibition, playing, or showing of the work to the public under the proposed Section 39, 5A3. And the difference between release, issue, and communicate to the public under the proposed Section 39, bracket 5. And also, in relation to proposed Section 45, provide supplementary information on the following issues. First, whether authorized recipients as defined in the proposed amendments to Section 45 regarding copyright exceptions to allow copying and communication of passages as extracts from published works for education purposes, etc. And for 45 brackets A, B, takes all reasonable steps. And what's the meaning of that? And the liability concerned. And for proposed Section 53, provide information on whether will constitute copyright infringement of a librarian, curator, of archivist, make a copy of an article or culture of historical importance or interest which was subsequently lost to Hong Kong through sale or export to a country which did not provide copyright exemption similar to that provided under Section 53, or if there was a provision in the reference sale and purchase agreement of the article which prohibited the making of such a copy. And the last question is about access to computer with criminal or dishonest intent. That is whether the government would make an undertaking that it was its intention to continue to keep the copyright regulatory regime separate from the regulatory regime for other computer crimes. First of all, about the first question. Communication of work to the public and the performance, exhibition, playing or showing of the work to the public. When what's the difference between the two? Communication to the public under Section 28A, which is a newly added right and a new act restricted by copyright, which refers to the electronic communication of a work to the public, including the broadcasting of the work, the inclusion of the work in a cable program service, and the making available of the work to the public. As for performance, playing or showing of work in public, acts restricted by copyright as stipulated in the existing copyright ordinance. That's under Section 27. Performance includes delivery in the case of lectures, addresses, speeches, and sermons, and in general includes any mode of visual or acoustic presentation, including presentation by means of a sound recording, film broadcast, or cable program of the work. Under the existing Section 27, a work in public, a difference in nature from the restricted acts of communicating the work to the public under the proposed new Section 28A. The restricted acts of public performance, playing or showing in public, concern with performances, playing or showing which take place in the presence of a public audience.
So that is the public performance, playing or showing in public concern with performances, playing or showing which takes place in the presence of a public audience. On the other hand, the restricted act of communication to the public under Section 28A is concerned primarily with cases where work is communicated through an electronic transmission process to the public, which is not present at the place where the communication originates. There is therefore a distinction between a direct representation or performance in public envisaged in the existing Section 27 and a communication to the public within the meaning of the proposed Section 28A. Our policy intent is the concept of performance, exhibition, playing or showing of the work in public should remain intact in the existing Section 27, separate and distinct from the concept of communication to the public in the proposed Section 28A. And other jurisdictions also share similar policy intent, as Hong Kong and held that the communication right does not intend to cover the conventional direct representation of performance in public, such as the live presentation or performance of a work. So that's the difference in the legal concept. As regards the difference between release, issue, and communication to the public under the proposed Section 39A, the proposed Section 39(5)(a) elaborates the meaning of release to the public for the purposes of the proposed Section 39(1)(a) and 2(a). A work will be regarded as having been released to the public if it has been provided to the public by various means. The issue of copies to the public is one of such means. If with the consent of the copyright owner, copies are circulated in places not previously put into circulation, well, we have a definition here. We say that does not include any subsequent distribution of such copies in the public circulation. In other words, issue of copies to the public refers to the first release or distribution to the public copies of a work, whether in hard copies or in electronic form. So there is a very minute distinction in law and in concept. So different terms are used in the bill to express this. And then proposed Section 45 defines authorized recipient. It means teacher or pupil of the establishment who has been authorized or on behalf of the education establishment to receive the communication. Under Section 195, subsection 2 of the existing copyright ordinance, the expressions teacher and pupil would include any person who gives and any person who receives instruction. So the title is not important. It depends on whether the person carries out some teaching functions, and therefore the definition is rather wide. And for students, if they are underage, their parents or guardians can, of course, exercise their rights under the law. And they are also authorized to receive such works on behalf of minors. So Section 45 is made with a specific purpose to address the situation in educational establishment and to provide teachers and students some flexibility in the use of copyright materials. But there are other provisions. For instance, under Section 38 for research and private study, Section 41A for the purpose of giving or receiving instruction, and so on. So these exemptions may be used separately or jointly. Some members asked, what about private tuition schools? Can they invoke Section 45? I don't think so, but they may use Section 41A because Section 45 only refers to established educational establishment recognized by the Education Bureau. Private tutors should not rely on Section 45. They should rely on either Section 38 or 41A. Exemptions under Section 45 covers copying or communication of copyright works by educational establishments for the purpose of giving instruction. So if these works are played for the purpose of education, it will not infringe the copyright in the works. Some members asked if on open days or recruitment activities, copyright works are used. Well, if the part used is not substantial, if it's just for the purpose of a briefing or an open day activity, the part used should not be substantial. Therefore, it should not be an infringement. However, if a substantial part of it is used to illustrate a certain point, then the new exception should be able to cover that. In Section 45, 1AB require educational establishments to take all reasonable steps to ensure that only authorized recipients can make use of the acts of the works. So education establishments should take reasonable steps. And only recipients that are intended to benefit under the ordinance can receive such works, and therefore educational establishments have to ensure that copyright works can only be accessed by means of a login procedure with a password, so that the scope will not go beyond the reasonable context. Some materials can be photocopied and also recirculated. And these are very common measures under available technology, and that's why we require educational establishments to take reasonable steps. And then Section 45 provides that if a copy is subsequently dealt with, it is treated as an infringing copy for that dealing, and if that dealing infringes copyright for all subsequent purposes. The policy intent is to offer exceptions, and only major beneficiaries under the ordinance can use copyright works, and therefore there must be some restrictions. Violation of Section 45(4)(a) will lead to civil liability because a person is not entitled to use the copyright works because he is not eligible for exception. And so the copyright owner may seek reliefs from court in civil proceedings by way of injunctions, order for damages, or accounts for profit against the infringer. Lastly, proposed Section 53. Items that of cultural or historical importance or interest will allow a librarian or curator or archivist to make a copy of such articles for preservation of culture and heritage, and the consent of the copyright owner is not required. If there is an agreement between the library or the owner or the purchaser, if there is no similar exception in the exporting country, what will happen? Copyright protection is territorial, so we can only govern acts in Hong Kong. In Hong Kong, we allow curators and librarians to carry out these exempted acts, and they are protected. And they will not be affected by jurisdictions that do not have such provisions. Lastly, Cap 200. Access to the computer with dishonest intent. We have said that the copyright legal framework will only regulate infringement acts. We will not introduce provisions outside our copyright ordinance to prosecute offences under this ordinance. Ms. Claudia Mo, thank you very much. Finally, you have told us clearly public performance or exhibition must involve the presence of an audience, and for electronic transmission, then there is no public audience present. I have a nitty-gritty question. For instance, there are news webcasts available is transmitted by electronic means. Will this kind be considered a kind of public performance? This is an excellent question. With technology advancing by leaps and bounds, if the communication is by means of electronic means, and somebody play it in front of a public audience, that involves two copyright acts. First, transmission by electronic means. And then the work is also broadcast or performed to a live audience. So this is a rather complicated situation. The presence of a public audience doesn't preclude the presence of other scenarios. So will the person involved have committed 2 offenses, or will he be just prosecuted for 1 offense? Under ordinary circumstances, the transmission of the works from far away and the one who plays it in front of an audience should be 2 different persons. No, I am not done yet. Para 11, reasonable steps. I think we are talking about flexible arrangements and depending on the actual circumstances. I think this is rather abstract. So you are tantamount to saying that it depends. Do you think that this is legally safe? You may call it a merit or dismerit of the common law. It really depends on the circumstances. This concept of reasonableness has a very long history in common law. So we have stuck to this concept because it all depends on the resources and technical capability of an educational establishment. Different educational establishments should take reasonable steps within their ability. For instance, copying and passwords, these are very easily available technology. So we are not putting extra burdens on educational establishments. We are only expecting to do what they should be able to do.
My question is about Crimes Ordinance 161. That is access to computer with criminal or dishonest intent. So people are worried that you will just use the easier section to prosecute people because it's very easy to use Section 161 of the Crimes Ordinance. And I was pleased to hear from the government that in 1993, when the Secretary for Security made his speech upon the resumption of second reading, he said that the offense has not been designed to tackle copyright-related activities, which are regulated under separate legislation. It is the administration's intention to continue to keep the copyright regime separate and not to use this provision for the prosecution of copyright offenses. This was what was said by the former Secretary for Security. And we are told that the government still enforces this now. However, there are copyright concern groups making such an accusation. They are saying that the government is dishonest because they have found a precedent in 2005. That's the big crook case. They found a judgment from a criminal magistracy. They said that in 2005, when the defendant was streaming 3 films at home, he is prosecuted as violating the copyright ordinance. And for the BTC he sold, he is prosecuted under Section 161 of the Crimes Ordinance. He made access to computer with criminal or dishonest intent, and he made other people benefit. And he was sued for under either of these two sections. So this has been there has been a precedent. So the accusation from the groups is very serious. That is, Deputy Secretary, you lied last time. The Secretary for Security said this in 1993. You try to prove that now the government is still adopting the same practice. But how about the big crook president? So what's the result? He was convicted of violating the copyright ordinance, and Section 161 of the Crimes Ordinance was not invoked because the other one already worked. So the netizen group asked me to put this question to you directly today. Who's going to answer this question? Thank you, Mr. Chen, for your question. Now, this is my response. As for copyrights, the relevant authority is the Customs and Excise Department. And under Section 198, the Commissioner is the authority. And for the 1993 Crimes or Computer Crimes Ordinance, second reading, we would have to look at the background at that time. At that time, the Commerce and Industry Bureau looked into this, and for CAP 2000 Crimes Ordinance, there might be some overlapping with the Copyright Ordinance, but it thought that these two areas should be separated. How should I put it? Well, take your time. The concern was that would it be for Section 161 of the Crimes Ordinance, would we be criminalizing certain acts accidentally? We have studied the relevant documents. That is, for people, they may copy computer softwares. Well, it's an infringement, but it's not a criminal liability. Well, under the Copyright Ordinance, there are a number of civil liabilities. Not all of them are criminal. If it's to be criminal, there is a major policy behind that, as you would have to use public resources to do the prosecution. So for Section 161, it was written like that. So would that be a risk? That is, would there be something unintended? That is, we don't want to criminalize certain things under the Crimes Ordinance, but it's accidentally criminalized. The policy intent is very clear. In the paper, we explained what the Secretary for Security said at that time. So for Section 161, it was not designed to tackle copyright-related activities, which are regulated under separate legislation. It is the administration's intention to continue to keep the copyright regime separate and not use this provision for the prosecution of copyright offences. This is a very clear policy intent, and it still stands today. So for Section 161, after it's enacted, we do not want to create new offences under which certain copyright-related acts are criminalized. We do not want to criminalize such acts under the Crimes Ordinance. So when the Customs and Excise Department enforces the law, it also adheres to this rule. So we will look at the Copyright Ordinance and the copyright regime. So it would not be targeting acts which have not been criminalized. So in 1997, the Copyright Ordinance was enacted. There have been a number of amendments since, and they were all about criminalized acts. For example, circumvention devices. For example, illegal decoder. This is clearly a copyright infringement. We think it should be regulated. For the illegal decoders, they should be criminalized. So we came to LegCo. We we discovered the problem, we conducted consultation, we amended the law, it was discussed at the LegCo. We enacted new rules to take care of such problems, and the Customs and Excise Department would work accordingly. The Customs and Excise Department has never invoked Section 161 of the Crimes Ordinance for convenience, because that's not our legislative logic. We have always been doing this. So this policy intent has never been changed. Big crook was one of the examples. So how do we look at it? First of all, for the act that was involved in the Big Crook case, that is the Infringement Act, it's actually distribution of copyrights of infringing copies, and it's already an offense. And it is something that the copyright ordinance should target at. So the court accepted our justification. It went from the magistracy to the High Court and then to the Court of Final Appeal. It was established that it was an infringing act, and it was something that the copyright ordinance should target at. And also for trying to prosecute with two possible offenses. Well, the Department of Justice made that consideration. So according to the basic law, it was the prosecuting authority. But we were mainly focusing on the act. We thought that the act was something that the copyright ordinance should target at. That's the basic principle. When the Customs and Excise Department enforces the law, it has never invoked Section 161 of the Crimes Ordinance. And for private copying, for example, I copy a copyright work, I have infringed the copyright ordinance. I affect the copyright owner. And I also use a computer to do that. Would it constitute the offense access to computer with criminal or dishonest intent? We have never tried to do this. The policy intent is very clear. I think this is what we have been doing. I hope I have explained myself clearly. This is our policy position. Yes. That's a long answer from the Deputy Secretary. But in 2005, Section 161 was invoked for prosecution. It's a fact. You said that ever since 1993, this has never happened. So you've missed the case or what? Because at the magistracy, the invoking of Section 161 was dropped, so it was not mentioned at the Court of Final Appeal. And now you are quoting what the Secretary for Security said in 1993. Did you know that at the magistracy, they did try to invoke Section 161 and the copyright ordinance to try to sue the Big Crook? I have told you about the policy intent. I'm not asking you about the policy intent. Were you aware that this happened? I do not remember the details, but for the Big Crook case, yes, it's a very famous case. I remember clearly that we invoked Section 118, that is the distribution of infringing copies, because at that time we thought that it was a criminal act. It used the BT technology, but it's an e-copy and it's covered by the ordinance. So it was very clear at that time he was infringing a copyright work, and under the copyright ordinance, that's a crime. So I am not trying to give the Deputy Secretary a difficult time. He said that he didn't remember. He remembered 118. He said he doesn't remember 161. Now let me ask about the future. Now you have stressed on this point. So in the future, will this happen again? What do you think? He has told you very clearly that under the copyright ordinance, he will be targeting infringing acts, but he will not invoke Section 161. He says that he's not going to comment on what the Department of Justice did. It happened in 2005. I'm not sure he knew what happened then. But last time he told us that this had never happened, but he might have missed this. That is, we now see this judgment from a magistracy. So we've seen the big crook case. And the copyright ordinance was proven to be more powerful. So maybe you do not need to invoke Section 161. Well, we are scrutinizing this bill. I don't think we should be scrutinizing what happened then. I'm not doing that because the Deputy Secretary has told us many times about the legislative intent. Yes, we are very clear about the policy. When we put together a policy, and when we legislate, we want a piece of legislation to follow our policy. But the Department of Justice tried to invoke Section 161 as well. Well, let us be cool. Just now you talked about set-top box. The Customs and Excise Department would also enforce the law in that area, and it would invoke the copyright ordinance instead of Section 161 of the Crimes Ordinance. The ordinance has been amended many times, at least 4 times. And during these amendments, additional offences have been added.
Because we knew very well that we wanted to deal with serious infringement act. If it is an offense, then we have to conduct a public consultation exercise, and we have to explain clearly to the public. We of the view that there should be some offenses created, and for this bill there are also criminal offences, and we have told members very clearly what acts we want to target. And we've also amended the provisions in 2011. That is our policy intent. All right. I help you to move forward. If in future the DOJ uses alternative offences under Cap 200, and also the copyright ordinance, I think what the Deputy Secretary said here can be used as evidence. And I don't think this will be used to tackle set-top boxes, right? And mobile phones or computers, and so are set-top boxes. Correct me if I am wrong. So is it true that you will not use Section 161 of Cap 200 to prosecute people who have purchased set-top boxes to view paid TV programs? Well, we confirmed what the Secretary for Security said back then, and when we discussed with the sector on enforcement, they knew our position very well. So if the Customs and Excise would like to enforce the law, we don't think that Section 161 applies. Well, if you say no, then we are more assured, because the users back then did not know that Section 161 was so all-embracing. Mr. Ma Fung Kwok, I have a question on Para 7, but to follow up on Mr. Chen Chi-chun's question, my understanding is that the purpose of our legislation is to punish offenders. So we should try our best to prosecute offenders. Whether there can be successful convictions should be left for the judge. At the point of enacting legislation, we should not think of ways to curtail the rightful powers and rights of law enforcers. I think the Deputy Secretary told us the purpose of the bill, whereas Section 161 of Cap 200 is from another perspective. One criminal act may be considered and two different offenses from different perspectives. We should leave it for law enforcement agencies to decide. We should not force a government official to make an undertaking, nor is the Undersecretary in a position to do so. If we use what the Undersecretary said this afternoon for evidence to be submitted in court, this is unreasonable. So I think what the Undersecretary said just now would only be within the scope of this copyright ordinance. I can understand why he could not answer Mr. Chan's question or had difficulty in answering his question. All right, my question relates to Para 7. Proposed Section 45, authorized recipient. Because the interpretation here can cover parents and guardians of minors. Or usually this is reasonable, but let's assume that a school wants to provide useful or meaningful electronic publications to their students, and students share it with their parents. So it might be used, originally it was used for an educational purpose, but the outcome may not be the same. For instance, there is a new movie on children or on young people, but it's also commercially, it has commercial value. And what if parents can view such works? What will be the outcome? Well, Para 7 is about an exception provided for educational purposes. Of course, I can understand Mr. Ma Fong Kwok's concern, but from an educational point of view, if a minor has to receive copyright work in the process with the assistance or support of his parents, now, the purpose is for education or educational related purpose, then it is entirely within the scope of exemption. I fail to see how the legitimate interest of a copyright owner would be seriously damaged, because the purpose must be related to education. So it's not just for entertainment. If this policy intent is clarified, we can understand why parents and guardians of minors can be covered. The reception of copyright works while assisting their children to receive education is entirely within the scope of exception. I understand your policy intent, but will this be abused? For instance, a new film on children or a relationship between two generations. The school may think that it is very educational and encourage students to view it together with their parents at home. If this is done in a massive scale, the interest of the copyright owner would be seriously damaged. Now, the law can never plug all loopholes of possible abuse, but the purpose of the legislation is to facilitate education, and reasonable exceptions are allowed. Now, if we do not do it, and in order to prevent a very unlikely abuse, how should it be drafted? Would it be the case that even parents and guardians of minors cannot receive such copyright works? That being the case, very young primary school kids may not be able to benefit. While we cannot rule the possibility of abuse, but I think that would be in a very small scale. But will be able to benefit students, primary students in particular. The benefits may outweigh the damages due to abuse. I beg to differ. On the one hand, we encourage creation of works suitable for young kids and families with young kids. And I think school children and their parents should be encouraged to view such movies at a concessionary price, for instance. And because what you propose here will seriously harm the interests of copyright owners. So in exercise, this exemption, there should be guidelines for schools. Schools must be cautious when dealing with such products, and they should avoid using such works. Mr. Wong, your comment? Mr. Charles Marks, before you. Chairman. Well, we discussed whether Section 161 will be used as an alternative offense in prosecution. First, I'm a bit worried because in another committee meeting or panel meeting, when we discussed this issue, I really felt that we should not trust the administration. Even an undertaking given in the second reading debate was useless because the Security Bureau accused me of being biased. And Mr. Chen Chi-chun only asked the Undersecretary a question, and I don't think it is adequate. You may reiterate that it doesn't matter. They could reiterate that point, and the second reading or debate is still useless because the same issue may emerge after a few years. So, Mr. Wong, I know this is beyond control, whether the Security Bureau can override the Commerce and Economic Development Bureau or the Intellectual Property Agency. I don't know. I don't know whether it is in your power to oppose the DOJ. I think the greatest protection for us, if, as you claim, that there's no policy change in policy intent, can you put it in black and white in the bill? I don't want the same to happen to this ordinance. Cap 161 was not properly drafted, and the administration has refused to review it. And now they know that Section 161 can be used in all sorts of scenarios. So they're not willing to amend the law, but we don't want this ordinance to be used in the same manner. I trust that you don't want to do so, but can you give us more assurance can you amend this ordinance so that everyone can be more comfortable? Copyright is under the portfolio of the CEDB, and the enforcement agency is the Customs and Excise. What are important rights that have to be protected? In the law, we do so by enacting legislation and amending the ordinance. We did so in the past, and we're doing the same this time. We clearly single out the acts that we want to tackle by creating offenses. So I think we have made our position very clear. We will use the copyright ordinance to address issues under the copyright regime. And we will do what we're allowed to do under CAP 582. We're honest, sincere. I don't think this is really addressing our issue. We are worried that this is the case for copyright regime. But I think Mr. Ma Feng-kwok was correct. He said that in a particular case for copyright provisions from this ordinance might be invoked, and then they may say that other pieces of legislation could be used to prosecute you as well.
So if you make it clearer here, then it would not cause confusion. That is, in a copyright case, you would sue the defendants under another piece of legislation. So would you consider this? That is what can be added so that people's doubt can be allayed. Deputy Secretary? Well, Ms. Mo has gently asked you to reconsider. Thank you, Mr. Mock. Well, for CAP 528, we will try our best to do within our regime. The LEA is the Customs and Excise Department, and we will try to improve the copyright ordinance. And if there are issues that are not addressed by this bill, for example, set-top box, then we will give you an answer in another paper. But I have reiterated, that is, we have stuck to our policy intent. For CAP 200, we will handle the computer or access to computer issue differently. This is the copyright ordinance. It's different. These are different regimes. And this is the understanding between the government and the copyright owners. Now, for example, if that's another big crook case, and then the police or another LEA may initiate the prosecution, then of course you would use the copyright ordinance to sue him. But then another department may ask to invoke Section 161 of the Crimes Ordinance. That is, it would sue the defendants at the same time under another ordinance. And for the intellectual property department, would you raise objection to that? Thank you for your question. First of all, yes, we are the same governments, but you may have different views. In 1993, you also put forward another opinion. In 1993, different bureaus were doing different things, so there was such an incident, but there was a consensus. That is how the government should work. It reflected the legislative procedures and why eventually the Secretary for Security made this remark. As for future cases, I cannot assume what will happen in the future, but I want to point out that this is our policy intent, and we would also uphold this spirit of the rule of law in Hong Kong, and the Department of Justice will initiate the prosecutions. Mr. Wong Yok-man, I have been trying to be patient. I'm only speaking now. There has been a heated debate about Section 161 of the Crimes Ordinance. Well, what can the government promise us now is quite meaningless. Some members raised these questions concerning Section 161. Now it's dug out the 1991 speech by the then Secretary for Security. It doesn't mean that this is a promise. It just says that when the piece of legislation was enacted, the then Secretary for Security said that. And this was debated at the Security Panel meeting just now. So discussing this here is quite meaningless. Now we are looking at the copyright bill, so I don't think he can answer you concerning those questions. So Mr. David Wong would give you a very ambiguous answer. Is this a question? Yes, this is a question, but a question that he cannot answer. And for Mr. Ma Fung Kwok's remarks, it says that you are forcing the government to do this and do that is inappropriate. Why is it not? What do legislators do? Legislators should not be the government's rubber stamp. We should be scrutinizing the clauses in great details, trying to find out the devil in the details. When the government tried to legislate on Article 23 of the Basic Law, we also found out the devils in the details. And now we are talking about different devices, set-top box, computers, etc. He says that there are still some devices that cannot be addressed by this bill. Mr. Chen Chichin also raised some questions. But these questions cannot be answered by the government officials now. This is an objective fact, so I don't think we should spend too much time on arguing all this. Well, when it comes to legislation, there would be a policy intent, and then there would be a legal concept. And then when we look at the provisions, we would look at them in great details. And afterwards, it would come the enforcement of the law. So when you enforce the law, if there are no bounds, it would be very dangerous. Hong Kong is eventually a place with the rule of law. We are not saying as what 698 always says, that is, ruling Hong Kong according to the law. Now the government is trying to answer members' questions and address the public's concerns. I still have a lot of opinions, but I don't have time to tell you all. I would like to make some responses here, though. Just now we talk about e-communications or communication of a work to the public, and the difference with the performance, exhibition, playing or showing of the work to the public. I don't find any difference between the two. Now for an issued works, I can say that, well, I have written a book and it's been published and you copy my book, of course it's an infringement. But when a book is published, it means that it's communicated. So is it not a form of communication? What I mean is that you will confuse people. Of course, I understand what you mean, but this is not clear. So for communication, here you would mean public showing. Well, this is what I will always do when I speak at the large go. It would be recorded, and I always play it at my office for the public to see. So it's what you said in Note 1, page 3, footnote 1. However, it is not uncommon for the public showing and playing of a work to be preceded by an electronic transmission process. For example, playing or showing a work in public via audio-visual equipment, such as a television or loudspeaker, by way of broadcasting. This is what's said in the footnote. And just now you should use this as an answer for Ms. Claudia Mo's question, in which case the acts may involve both the playing and showing of a work in public and communicating a work to the public. This explanation is not clear enough. There are still ambiguities. And if this is purely about 39(5), then what's the difference between release, issue, and communicate? I don't see a difference. Well, according to your, when people, ordinary people look at it, they may not find a difference. But I've told you that copyright ordinance is very complicated. So for issue copies to the public, it means it's the first time. So when you write a book, issuing it means publishing it for the first time, and it can be in a physical or tangible form, or it's an e-copy or an e-form. Is that tantamount to e-communication? But that is an independent concept. How about e-books? If it's the first time it's published, then it would be issuing to the public. But you have to remember the concept. Issue means the first time. If it's been published, then we would no longer use the word issue. As for communicate and release, it's not about the first time. The thing that has been communicated can be communicated again. So this is a copyright law concept. As the first time is published. When you talk about communication, it is a new restricted act. But for the word communication, why has it become a new restricted act? Why? Well, issue is also a restricted act. I'll try to answer your question. If it's communication, then we should try to look at it from a broader perspective. Well, we should not give the word a new meaning. Communication to the public here is communication through an electronic means. This is one of the means. Here we try to elaborate further. That is, other than through electronic means, there are other means, and they would be regarded as having been released and issued to the public. They may be in a physical form, or they may be distributed. I think the purpose is to explain in simple terms to the users as to wonder what circumstances can they enjoy the exemption, that the works must be public or open. And these are the works owned by the copyright owners. So it's the first time that it's made public. So for issue is for the first time. So for communication is through electronic means publicly. So for 39(5), if you go to the courts, of course, the courts would understand it. However, it's not clear. Yes, I'm trying to pick on you, but I am still thinking that they are quite confusing. If members have no other question, well, please give me some time. I would like to respond to Mr. Ma Fong Kwok. 1 minute. About set-top box. When I asked the question, I didn't mean that set-top box shouldn't be regulated. But I would like to ask the government, would it invoke 161 to regulate set-top box? And the Deputy Secretary said no. And at the meantime, he doesn't want to cover it. Because for set-top box, there may be new discussions. I think we need new provisions to take care of that, not Section 161. I asked the question because I want the Deputy Secretary to assure us that he is not going to invoke 161 regarding such devices as the computer mentioned under 161. If members have no other questions, then we are still waiting for 3 documents from the government. The next meeting will be on the 9th of June. It's a Tuesday, 8:30 in the morning. We'll adjourn today's meeting now. Deputy Secretary, do you want to add anything? 8:30 in the morning, not 9:30.